So what we're going to talk about today is we're going to talk about stay put and its implications. And stay put is something that's a part of the IDEA. It applies in the 50 states. Individual states can do it a bit differently. And usually the way that works is the federal law is kind of like the foundation. And if states want to give more rights than that, they can. So your state, if you're not in California, might have a different set of rules as pertains to certain aspects of stay put, but the general concepts are the same from state to state. So I find that oftentimes parents haven't been told about stay put. It's there in your procedural safeguards that they hand you at the beginning of the IEP, but nobody's necessarily explaining to the parent that this is an important concept to understand. The thinking behind stay put was that there had to be predictability and protection of the student in the event that there was a dispute, and that the best way to achieve that would be to preserve the status quo until this dispute could be resolved. And so the practical effect is the district can't just change your placement if they want to without having to contemplate the possibility that there would be a process. So if you go to your IEP and the district says, we don't think mainstreaming is working out, or let's take another one. We don't really think you need this aid anymore. We don't think this behaviorist is really doing anything. They just sit at the back of the classroom. We want to take them out of your IEP. You have the ability to enjoin the school district from doing that, meaning you can get sort of an automatic injunction under the IDEA. And the way you do that is you file a complaint for due process. And as soon as you file that complaint, it has the effect of preventing a change in placement. So there are a lot of different instances in which that could come up. And, you know, with private schools, one of the things the districts do is if they pay for a year of a private school after a dispute, they will write right into the settlement agreement that the FAPE is the IEP of blah, blah, blah data, not the settlement agreement, because they don't want you to come back and say, okay, we have a disagreement. You don't want to pay for private school anymore. I'm stay putting the private school. But if you could get them to write that the private school is stay put, and, you know, of course, sometimes we've all, you know, in certain cases had that happen, that's obviously better. So the first thing that I want you to understand is that you have this right that's called stay put, and it's triggered by filing for due process. And that once you file for due process, the district has to maintain the current educational placement until the appeal process has been exhausted. So typically, some states it's only up to and through a district court decision. Other states, you'd have the right to actually appeal to the federal appellate level and get your decision reviewed. But certainly the reason districts don't like stay put is because they understand that a person can tie up the placement for 2 or 3 years in litigation. But it is child protective, and the district, you know, one thing they're pretty good about is they don't tend to violate stay put orders. They tend to follow them. So you get into.
Can I jump in there and make a comment, Bonnie? That I think a lot of times as parents we feel powerless, and sometimes, I mean, you know, parents will write in all the time and go, you know, we were doing X, Y, and Z, and then the school decided to do Q. Mm-hmm. And what are my rights? And I think that this goes right to the core of two things: that you can't be bullied. That they can make a decision to change something, but you have the right to put a stay put in. But this is also why I always say to parents, some parents get so stressed about going to the IEP meeting that they go, does it really make a difference what's in the IEP? Like, why don't I just say yes to whatever they say, and then we'll slog it out and sort it out later on, and we'll see if because the school will tell you, well, let's just try what we're asking. Why don't you just sign the paper? We'll just try what we're asking, and then we'll see where we get. But if it's already in the document that your child is supposed to get something, because of the stay put, they can't bully you out of it. And that's for me one of the reasons why it's so important to get it in the document to begin with, because I just heard you say is that sometimes the legal schmiegel, when you fight it out, takes months and years. But in the meantime, if your child is getting the services and you did the stay put, then it doesn't matter whether it takes years for it to work out, because
no,
you
might want it to take years. I mean, I'm not embarrassed to tell you that in the good old days with LA Unified, they didn't even require us to file, and we would have kids that had like a full 30-hour ABA program, and we would just invoke stay put, and like 3 years later, the district would finally get around to dealing with it. But I mean,
and by then they didn't need 30 hours anymore, maybe, because they've done so well.
Maybe not. I mean, the thing is, you got to remember, if it's offered in an IEP, you have to consent to it, or else it's not stay put. If it's never implemented, but it's in an IEP, it's not stay put. It has to actually be the last agreed upon and implemented placement.
That's an important distinction.
Hey, thanks for watching Autism Live. To subscribe, click here. And if you'd like to check out some more of our videos, click here.